Welcome to the Business Law 280 review of Chapter 12, Consideration. This chapter is designed to familiarize you with the concept of consideration, which has been described as the glue that holds the bargain together at common law. There are several learning objectives that we will explore throughout this chapter. After reading this chapter and listening to this lecture, you should be able to define the concept of consideration and describe its significance in the formation of a valid contract. Explain the elements of consideration. Explain why illusory promises, past consideration, and promises to perform pre-existing obligations are not consideration. And finally, determine what is required to create a valid modification of a contract under both the common law and contracts of the UCC. Our opening vignette is as follows. The Valley Area Anti-Smoking Foundation, VAAF, offered to pay any Valley Area resident $500 if he or she would refrain from smoking for 1 year. Chad, a Valley Area resident, decided to accept this offer. He quit smoking immediately and did not smoke for a whole year. When Chad contacted VAAF to inform it of his success and collect his $500, VAAF informed him that it was able to only pay $250 because so many Valley Area residents had taken advantage of its offer. Chad reluctantly agreed to accept $250 instead of $500. The questions you'll be able to answer by the end of this lecture are as follows. Was VAAF contractually obligated to pay Chad for refraining from smoking? Was there consideration to support its promise to pay $500? Are there other facts you need to know to make that determination? Is Chad entitled to receive the entire $500 or only $250? Let's start with our first learning objective, which defines the concept of consideration and describes its significance in the formation of a valid contract. The consideration requirement reflects the common law notion that the purpose of contract law is to enforce private bargains. Promises not supported by consideration are generally unenforceable at common law. The consideration requirement limits a promisor's liability for his promises. He is not liable for gratuitous promises or for a promisee's reliance on such promises. This limitation on the scope of a promisor's liability can sometimes work a hardship on promisees. The terms promisor and promisee are important. In bilateral contracts, both parties are promisors. Each made a promise to the other. And both parties are promisees. Each receives a promise from the other in return. This may cause confusion when trying to formulate an answer to a question. So think of the following questions to keep the parties straight. Which promise is at issue? That is, the promise made by the party seeking to avoid performance of the agreement. 2. Who is the promisee? Which party was the promise at issue made to? Meaning who is seeking to enforce it. 3. Has the promisee given consideration? Meaning, has the legal value bargained for and given in exchange for an act or a promise? This is a better definition than the benefit to the promisor or detriment to the promisee test, as it is less confusing and ties in better with the various rules for consideration. So once we understand that promisor-promisee relationship, we can differentiate who made the promise, who's trying to enforce the promise, and who was required to give the consideration. So let's look at a couple of hypotheticals to see if we can determine who the promisor and who the promisee was. In our example, Ace Painting Company agrees to paint Steve Smith's house for $2,000 payable on completion. Ace refuses to honor the agreement, having received a more lucrative contract. Smith files suit for breach of contract. Which promise is at issue? Here it is Ace's promise to paint Smith's house. Who is the promisee? Smith is the promisee. Has Smith given consideration? Yes. Smith promised to pay Ace $2,000, something he had no legal duty to do, which we will find out is the legal value, and what Ace asked for in exchange for making his promise to paint, which is the bargained for and given exchange. What if we switch up the facts a little bit and Smith tries to cancel the contract, having received an offer from Budget Painting Company to paint his house for $1,500? Ace now files suit for breach of contract. Which promise is at issue? It is Smith's promise to pay Ace $2,000 to paint his house. Who is the promisee? In this situation, the promisee is Ace. Has Ace given consideration? Yes. Ace has agreed to do something it had no legal duty to do, the legal value, in exchange for Smith's promise of payment, which is the bargained for and given exchange. Keep in mind that consideration can be either an act in a unilateral contract or a promise in a bilateral contract. What can sometimes be confusing is that in a bilateral contract, the promisee who makes the requested promise has given consideration even though he may not have actually performed yet. Thus, in the first part of the hypo, the fact that Ace has not yet painted Smith's house will not prevent Ace from winning a breach of contract suit against Smith. Ace must merely allege that it is ready, willing, and able to perform. With this process of determining which promise is at issue, who the promisee is, and whether the promisee gave consideration, you should be able to solve any consideration problems. Let's now focus on the actual elements for consideration. From the hypotheticals, hopefully you have already determined that there are two elements for consideration. Those two elements are 1, legal value, and 2, bargained for exchange. To have legal value, a promisee must do or agree to do something he has no duty to do, or not do or agree not to do something he has a legal right to do. This requirement has two major implications. The promisee's act or promise need not have any monetary value to the promisor to amount to consideration. And second, it is not essential that the promisor personally derive any value from the promisee's promise. Think of a guarantee contract. Tom Jones has a younger brother named Mike. Mike wishes to rent an apartment. The landlord refuses to rent to Mike unless Tom agrees to guarantee payment of the rent. Tom agrees, but later Mike leaves town owing the landlord $1,000 in unpaid rent. Is Tom's promise enforceable against him? Yes. The landlord has given legal value in exchange for his promise by renting an apartment to Mike, something the landlord had no duty to do. To be bargained for, the value must be sought by the promisor in exchange for the promise to be given. Generally, courts will not inquire as to the adequacy of the consideration. This keeps in line with the classical contract law principle of a hands-off posture that the courts traditionally assumed towards private agreements and promotes certainty in contract cases. However, it is at the potential cost of enforcing unfair agreements. However, inadequacy on the face of the agreement may justify denying enforcement. Gross inadequacy of consideration may indicate a lack of contractual consent or capacity. Gross inadequacy of consideration can also result in a denial of equitable remedies to a party seeking to enforce the agreement. Many courts will not enforce agreements supported by mere nominal consideration unless they find that the stated consideration was truly bargained for. A few courts have simply refused to enforce contracts involving consideration which is so inadequate as to, quote, shock the conscience of the court. These are still in the minority, but it is possible that they represent the first signs of a revision of the general rule on adequacy of consideration. So let's look at our first case which talks specifically about legal value. This is Franchise Holding II LLC versus Huntington Restaurants Group, Inc. To give consideration, a promisee must do or agree to do something he had no duty to do. Again, or not do or agree not to do something he had a legal right to do. In Franchise Holding 3, plaintiff won a default judgment against defendant for nearly $25 million. Eventually, the parties entered an agreement to stay plaintiff's attempt to execute judgment, which involved defendant paying $13 million of that total default judgment on an installment plan with a specific timetable. In addition, defendant agreed to do several other things, including agreeing not to challenge the judgment in court, notifying the plaintiff if it created any subsidiary organizations, not paying one of its principals any compensation, and giving plaintiff access to financial records of its subsidiary organizations. If the defendant failed in any of these requirements, the plaintiff's agreement to stay execution of the full default judgment would lift, and plaintiff could seek to collect the full amount. After 2.5 years, the defendant missed a payment, and plaintiff sued for breach of the agreement. Defendant argued that the agreement for stay of execution upon judgment was invalid for lack of consideration and moved to dismiss the claim. So let's look at how the court framed the issue. Whether Huntington Restaurants Group, Inc. gave consideration when signing the agreement for stay of execution upon judgment. The rule it applied was that a benefit to a promisor or a loss or detriment to the promisee is good consideration to legally support a promise. Under the facts of this case, franchise promised to forbear on enforcement of its judgment. In addition, Huntington promised not to challenge the judgment and withheld compensation from a principal. In conclusion, both parties furnished consideration. Summary judgment to Franchise Holding II LLC was granted. As a side note, before getting to the current issue, the agreement to pay less than the full amount of liquidated debt is explored later in this chapter. So here, the promises that were made were by both sides. The important part of Huntington's promise was that it was more than it was otherwise legally obligated to do. It would not challenge the judgment, and it withheld compensation. Part of its argument was, well, the plaintiff here, Franchise Holding, could have just garnished the wages and got a judgment to enforce against them. But the court said that's not enough. The most that they could have received under a garnishment was 25%. Where here, the company was agreeing to withhold 100%, which was more than it would have otherwise been able to do. So there was valid consideration. The second element we discussed was bargained for exchange. Legal value is not sufficient on its own. Legal value is not consideration unless it represents the promise or thing that the other party was looking to receive and induced that party to make its own promise or act in return. In the Steinberg case, the Joint Congressional Committee on Inaugural Ceremonies sought to give away 240,000 tickets to the general public to view the inauguration of past President Barack Obama. Michael Steinberg obtained 2 tickets from his congressman. He traveled from Florida to Washington, D.C., but once he was there, he was refused admittance and was unable to view the inauguration. Steinberg claimed that the Joint Congressional Committee knew that some tickets would not be granted admittance, but they did not inform those ticket holders of that possibility. He sued for breach of contract for failure to notify of the risk of non-admittance and for failing to honor the ticket. The court looked at the issue by stating whether there was consideration given by Steinberg. To constitute consideration, a performance or a return promise must be bargained for. It is bargained for if it is sought by the promisor in exchange for his promise and is given by the promisee in exchange for that promise. Applying that rule to the facts of this case, Steinberg claimed having to pick up the tickets from the congressman's office was the consideration. However, that was not a mandatory requirement and therefore could not be consideration. Steinberg also claimed that the cost of travel was a detriment and was the consideration. A detriment is consideration only if bargained for. The cost of travel was not bargained for or sought by the government in exchange for the ticket. So in conclusion, the U.S. did not receive a bargained for benefit from the spectators who attended the inauguration. Therefore, there cannot be consideration. So now how do we see whether or not there is no consideration? There are several different types of acts or promises that will not meet the burden of the elements of consideration. The first are illusory promises. An illusory promise cannot amount to consideration. Where the consideration is so insubstantial that practically speaking no obligations are imposed, there cannot be said to be consideration and therefore no contract. This is due to the lack of mutuality because only one party is bound to perform. When a court says that an agreement lacks mutuality of obligation, what it is really saying is that one of the parties has not given consideration to support the other party's promise. The book went through the case of Day versus Fortune High-Tech Marketing, Inc. Day represented a class of independent representatives for Fortune High Marketing, Inc., FHTM, which was a multi-level marketing company. Day sued FHTM under state and federal consumer protection and anti-racketeering laws on the theory that FHTM was an illegal pyramid scheme. FHTM moved the court to compel arbitration, arguing that all independent representatives signed an agreement with FHTM that incorporated the FHTM policies and procedures, which included a mandatory arbitration agreement. The policies and procedures also, however, reserved to FHTM the right to modify the agreement at any time and without notice. The district court refused to compel arbitration, so FHTM filed an interlocutory appeal. So let's look at what the issue was. Whether the court must compel arbitration. Our rule is so long as the contract as a whole is supported by consideration, the arbitration clause would be valid. Applying that rule to the facts of this case, looking at the contract as a whole and whether there was consideration, the clause that allowed FHTM to modify the contract at will made it illusory because FHTM was not bound by anything in the contract. Therefore, the arbitration agreement should not be enforced because the contract as a whole could not be enforced. Note that a unilateral right to cancel or terminate an agreement can sometimes operate to render the agreement an illusory one. The code under UCC 2-306 has resolved many of the problems that used to confront courts seeking to reconcile output requirement contracts, which are ones that do not specify a specific quantity of a good to be produced or purchased, and exclusive dealing contracts, with the rule that illusory promises could not constitute consideration. The code imposes a standard of good faith, which is further discussed in Chapter 19. What about past consideration? This term, past consideration, is actually a misnomer, but sticks because it has been used for so long. It is really an act or a benefit that was given in the past and therefore cannot be current consideration for the current problem. The Doe case is the one explored by the casebook on this issue of past consideration. Jane Doe was sexually abused by a priest when she was a teenager. She suffered emotional and mental challenges into her adult life as a result. On her behalf, her husband contacted the archdiocese demanding compensation. While they were rebuffed on the monetary claims, the archdiocese did agree to pay for Doe's therapy and counseling. After about 5 years of paying for her services, the archdiocese dramatically cut back its support. Doe sued the archdiocese claiming breach of contract. The archdiocese defended that there was no contract because it had no legal obligation to pay. It was doing so out of a moral obligation, which the Does had previously admitted. The trial court granted the archdiocese motion for summary judgment, finding that it had no legal responsibility to continue paying all of Doe's continued therapy costs, and Doe appealed. So really what Doe was saying was that it was morally obligated to continue to pay because that's what it had done for the past 5 years. So let's look at how the court resolved it. The issue was whether the archdiocese was legally and morally obligated to continue paying for Doe's therapy. A promise must be predicated upon adequate consideration, and a moral obligation to perform does not provide sufficient consideration. The policy on care of victims gave guidance and specifically stated that the policy does not constitute a contractual undertaking. In addition, the letter from the Does to the archdiocese specifically acknowledged no legal obligation, but pointed to a moral obligation. Therefore, there is no enforceable contract. The last one are pre-existing duties. In addition, generally performing or agreeing to perform a pre-existing duty will not amount to consideration. This directly affects the legal value requirement to consideration. The promisor who receives such a promise or performance has in effect received nothing in exchange for his promise because he had only received something he was already entitled to. There are a couple of different types. The first one, public duties. Pre-existing public duties. How do you think it would be handled if a police officer claimed a reward for apprehending a felon when the police officer was on duty? What about contractual duties? They have their own set of issues discussed in the next section. This forms the basis of the traditional common law rule that an agreement to modify an existing contract must be supported by some new consideration to be binding. So let's look at then, how do we modify contracts under both the common law and the UCC? There is criticism of the pre-existing duty rule as a basis for determining the enforceability of contract modification agreements. Many observers argue that most courts, in fact, are applying the pre-existing duty rule in a manner calculated to reach fair results by finding some new consideration to support fair modification agreements, or by finding some unforeseen circumstances that justify enforcing such agreements. Courts may also enforce fair modification agreements by finding that the parties mutually agreed to terminate their original contract and subsequently enter a new agreement. The Welsh case illustrates the common law approach to pre-existing contractual duties. However, the court finds no consideration to support the modification. The Welshes brought their Volkswagen Touareg to Lithia Volkswagen of Des Moines for evaluation and eventual repair. Mr. Welsh authorized Lithia to do repairs for a price certain. Lithia performed the repairs discussed with Mr. Welch, plus additional repairs for which it did not charge the Welshes. When Mrs. Welsh appeared to pick up the car and to pay, Lithia had her sign an invoice, which included a mandatory arbitration clause the parties had never previously discussed. When the repairs Lithia performed turned out to be inadequate and the Welshes sued, Lithia asked the court to compel arbitration based on the clause in the invoice. The courts refused and Lithia appealed. Volkswagen argued that the contract was entered into on March 16th when Mrs. Welsh signed the invoice, and therefore the terms of the invoice were included within the contract. The Welshes argued that the contract was entered into on January 14th when they authorized Lithia to do the repairs. So let's look at how the court framed the issue. Was there any new consideration given when the invoice was signed? Where parties to a contract modify the terms, there must be some new and valid consideration. A promise to perform a pre-existing duty generally does not constitute additional consideration. The invoice signed on March 16th was signed after all the repairs were completed. Mrs. Welsh did not seek anything in exchange for the promise to arbitrate. Lithia already had a pre-existing duty under the oral contract to evaluate and repair the car at a set price, which it did. The arbitration clause was a request for a new unilateral contract for which there was no new consideration. In conclusion, the denial of the motion to compel arbitration is affirmed. Now, this next point is not in your text, but you should know it anyways. The restatement section 89 provides that an agreement modifying a contractual duty under a contract not fully performed by either party is binding if the modification is fair and equitable in view of the circumstances not anticipated by the parties when the contract was made, or to the extent that justice requires enforcement in view of material change of position in reliance on the promise to modify. Now, what about under the UCC? UCC 2209 has changed the pre-existing duty rule for agreements to modify sales contracts. 2209-1 substantially increases the risk that persons may fraudulently allege the existence of an agreement to modify sales contracts. Consideration plays an evidentiary role in that it furnishes evidence of an agreement's existence. Subsections 2 and 3 of 2209 are designed to minimize the risk of fictitious agreements. What about certain debts? Debts are resolved under doctrines of common law. A liquidated debt is a debt that is both due and certain, meaning the parties know the exact amount of the original debt. An agreement to settle a liquidated debt for partial payment at or after the due date is unenforceable for lack of consideration. By negative implication, this means that an agreement to settle a liquidated debt for part payment before the due date is enforceable. An unliquidated debt is a debt where there's a dispute about either the existence of the debt, is it really due, or the amount, is it really certain. The settlement of an unliquidated debt is called an accord and satisfaction. An agreement to settle an unliquidated debt for part payment is enforceable. Think back at the beginning of this presentation. What is the promise at issue? It is the creditor's promise to accept part payment in full satisfaction of the claim, not the promise to actually pay. The last example are forbearances to sue. A forbearance can amount to legal value if the agreement was made in good faith, meaning the promisee must have a good faith belief in the validity of that legal claim before forbearance amounts to consideration. So here is a recap, which is actually from your text in chapter 12 on page 417, that sets forth two separate columns of what you can consider, generally speaking, consideration or not consideration. So here are the examples of consideration, assuming it is a bargained for exchange. Doing something you had no pre-existing duty to do. Promising to do something you had no pre-existing duty to do. Paying part of a liquidated debt prior to the date the debt is due. Paying a liquidated debt in a different medium of exchange than originally agreed to. Agreeing to settle an unliquidated debt, or agreeing not to file suit when you have a good faith belief in your claim's validity. Now, what is not consideration? Doing something you had a pre-existing duty to do. Promising to do something you had a pre-existing duty to do. Nominal consideration unless it is actually bargained for. Paying part of a liquidated debt at or after the fact that the debt is due. Making an illusory promise. Past consideration or a pre-existing moral obligation. So we spent a lot of time talking about consideration, but there are some instances in which consideration, the requirement for consideration, can result in an injustice. And so the courts and the legislatures have carved out exceptions to the requirement of consideration. The first is promissory estoppel. Promissory estoppel is a substitute for the consideration requirement. You have already seen from previous chapters how promissory estoppel prevents offerors from revoking offers on which offerees have foreseeably relied and allowing the enforcement of indefinite agreements. However, the most widely accepted use for promissory estoppel is in the consideration context, and we'll deal with the McClellan case in just a moment. Promises to pay debts barred by statutes of limitations. Many states will enforce a new promise by a debtor to pay an expired debt, even though technically there is no consideration because the creditor has given nothing in exchange for the new promise. However, that new promise must be in writing. Promises to pay debts barred by a bankruptcy discharge. Like a new promise to pay after the statute of limitations has expired, courts will enforce new promises to pay a debt after a bankruptcy discharge if the debtor reaffirms the debt. There are a series of technical steps that must be followed in accordance with the Bankruptcy Reform Act of 1978, which are beyond the scope of this course. So all you need to know is that they can be enforced so long as it's in writing, even though there's been no consideration. And the last concept are charitable subscriptions. Promises to make gifts for charitable or educational purposes are often enforceable despite the absence of consideration if the institution, organization, or charity actually relied on that promised gift. Okay, let's look at the McClellan case now, and we're focusing most specifically on the promissory estoppel element of it. Charlie owned land in Madison, Wisconsin, in a prime location for the expansion by the University of Wisconsin because it was situated between two lab buildings in which research involving primates was done. The land was also seen as valuable to animal rights activists who intended to use it for an exhibition hall on primate research as a protest. When the university offered to buy the land from Charlie, he demanded $1 million. The university initially declined. Then Bogle, an animal rights activist, negotiated to buy the land from Charlie for $675,000. It was actually $750,000, but there was an option if he bought it within a certain period of time. This purchase was to be financed by McClellan, who borrowed the money on the promise that Bogle would make the payments on the loan. Charlie and McClellan signed a document entitled Option to Purchase. Shortly thereafter, but before any purchase was initiated, Bogle and his supporters held a rally on the land with a sign touting it as the future home of the exhibition hall. That prompted the university to offer Charlie the $1 million asking price. Charlie, having contacted an attorney and determining that the option to purchase was not a legally binding option, ultimately decided to sell to the university instead of McClellan. So McClellan sued, claiming breach of contract and promissory estoppel. The trial court found that the option was enforceable, and thus Charlie breached the contract. However, it found no basis for promissory estoppel liability. Charlie appealed the contract verdict, and McClellan appealed the promissory estoppel ruling. The appellate court noted that an option must be supported by some consideration in addition to the promise of the ultimate purchase price to be enforceable. McClellan argued that there were 4 bases to show the required additional consideration. 1, that certain terms in the option to purchase document detailed elements of the sale that Charlie bargained for. 2, that the option to purchase showed an intent for Charlie to be bound. 3, that Charlie got personal satisfaction from tweaking the university by selling to the animal rights activists. And 4, that McClellan's attempts to find financing were valuable. The court rejected each of those, and so did the appellate court. There was no consideration for the option that was separate from the consideration for the sale. As for the promissory estoppel argument, the court considered 2 promises. First, the promise to Bogle to sell him the land initially if he could find investors, which allegedly led him to stop looking for teaching jobs, move to Madison, and to engage in fundraising and planning for the exhibition hall, all of which purportedly were with the full knowledge of Charlie. The second promise was that McClellan argued that Charlie's promise in the option to purchase document was subject to promissory estoppel because McClellan relied on that promise. So again, just focusing on the promissory estoppel issue, whether Bogle has a claim for promissory estoppel based on the promises made by Charlie. The rule, a party will prevail on promissory estoppel if 1, the promise is one that the promisor should reasonably expect to induce action or forbearance of a definite and substantial character on the part of the promisee. 2, the promise induce such action or forbearance. And 3, injustice can be avoided only by enforcement of the promise. In applying that rule to both promises made by Charlie, Bogle's actions following his conversations with Charlie were insufficient because they were not in reasonable reliance on the supposed promise, and Charlie could not have foreseen that those actions would follow given the preliminary nature of the conversations. As to the second promise, he had admittedly done nothing in reliance between the time he signed the option to purchase and when Charlie notified him that it was invalid. In conclusion, there was no contract because there was no separate consideration, and there was no promissory estoppel. Going back to the opening vignette, we can now answer those 4 questions. Was VAAF contractually obligated to pay Chad for refraining from smoking? With regard to consideration, Chad gave consideration if he had the legal right to smoke. He was agreeing to stop doing something that he had a legal right to do. Was there consideration to support VAAF's promise to pay $500? If Chad had the right to smoke and gave up this practice, this meets the requirements of consideration. What other facts do we need to know? And is Chad entitled to receive the entire $500 or only $250? One important fact to know is how old Chad is and whether he is in fact legally permitted to smoke under state law. He has the right to receive the entire amount promised if there is an enforceable contract.